you are comfortable because you are waiting for lunch.
No.
No? Okay, so I have 20 minutes. Okay, thank you very much. Professor, Doctor, Minister, dear Pleno Titulo, ladies and gentlemen. First of all, I would like to thank Dr. Katarzyna Zombory and of course Professor Ede Szilagi for the opportunity to participate in the Central European Professors Network. Many thanks of course for the Peter Pazmany Catholic University, ideal place for me for this conference international. Thank you very much, Professor Bandi, for that opportunity. First of all, I have to start with a basic assumption of my presentation that given legal norms cannot be separated from the values which are encoded in those norms. It's a bit, I think, obvious fact. We call it in Poland not only a unity or integrity of norms and values in the legal system. So I should suggest a definition of the value, of a legal value, which I will be using. I mean, these are certain positive states, things, phenomena, objects or events, past, present or future, which the legislator regards as valuable and therefore requiring protecting by means of adequate legal norms. So the value is a quality of preciousness, of something. I would say something like that. It seems to be obvious fact that the Constitution is of particular, of fundamental importance for identifying the axiology of legal system of a given state. It's a pillar of that legal order, expressing a particular set of values. I wouldn't call it a system of values, which constitutes the identity of a nation. According to the title of my presentation, the Polish Constitution refers to the notion environment in 5 articles. You have it on the presentation, but no definition of this notion is suggested in the Constitution. But the fundamental law emphasizes in particular the obligation to protect the environment. This is I think, the most important provision, rule maybe from these provisions. No provisions in particular connecting with natural resources, for example. Yeah? Against this background, background of these provisions, these 5 provisions, the Constitutional Court identifies a value which it calls, the Constitutional Court calls it natural environment, healthy environment, or even environmental protection. For me, that indicates that the CC uses the notion of a value loosely, mixing indeed the conceptual categories within its framework. Referring to the first proposal, I mean natural environment. There is a valuable view of the CC in judgment KP 209, in which we have a definition of the environment for the definition of the constitutional notion of environment, and it was by the CC it was described through the prism of statutory provision. Statutory provision, I mean the General Act for Protection of Environment, Environmental Protection Act. And this definition you have on the slide. Yeah? All natural elements, including those transformed as a result of human activity, and in particular the Earth's surface, minerals, and so on, as well as interactions between those elements. And we can ask, is the environment a value? For me, it is a bit even obvious that the environment is not a legal value in the sense adopted in this presentation. I would say that generally speaking, only a value only may be constituted by an appropriate, desirable state, condition of the environment. So in that view, I would consider the CC view identification of a value of a healthy environment to be correct. Yeah? And according to Article 68, subsection 1 with connection, subsection 4 of this article of the Constitution, one of the means of realizing the subjective right to health protection is preventing the negative health consequences of degradation of the environment. In this way, the constitutional legislator, for me, has clearly specified, and also for the Constitutional Court in some judgments, specified the state of the environment that he desires. It is one that does not have negative health consequences for humans. That's the value for me, according to, of course, my vision. The second provision, important for the values connected with environment. Article 74. Constitution mentions ecological security among those values, linked of course with environmental protection. Public authorities shall pursue policies ensuring the ecological security of current and future generations. And it has no definition in the Constitution directly, but we have a definition of the CC on this provision. It means bringing the environment, so of course it is connected with protecting of environment, to a condition allowing safe human existence in such an environment and using such an environment to enable human development. So, through this prism, we can say that another value connected with environment is ecological security or ecologically safe environment. The third provision, and the last for me provision of the Constitution, which explicitly links certain values to the protection of the environment, is Article 74, subsection 3 of the Fundamental Law. Everyone shall have the right to be informed of the quality of the environment and its protection. Therefore, the constitutional legislator regards broad access to environmental information as a value. Article 74, subsection 3 is also the only provision of the Polish Constitution that establishes expressis verbis a subjective right of the individual related to the environment. So no right to environment in general, in Polish Constitution directly. Furthermore, it should be noted that the values that make up axiological basis of the constitutional norms, of course also the values mentioned above, interact differently with each other. So the values may either complement, collide, or take a neutral position with respect to each other. So, firstly, they may form some kind of sequences of jointly protected values. I mean, in relation to values, example, healthy environment, ecological security, people's health, security of citizens. Secondly, values may clash with each other. If the implementation of one value is achieved at the cost of realizing another value. Example, security of the state or versus broad access to environmental information on freedom or freedom of economic activity versus healthy environment. And thirdly, we may have a situation where the achievement of one value is neutral with respect to another value. Example, broad access to environmental info and employment. Obviously, obviously, the most sensitive cases are those where the values collide. So we need to resolve this problem and decide, we, of course, the legislator mainly, which values are to be prioritized and applied, and which are to be treated of a secondary importance or not applied at all. This conflict of the values would be resolved by using so-called mechanism of weighing up values, or the mechanism of axiological calculus, we can call it in that way. And this mechanism is applied at the lawmaking stage, when the legislator decides which value is more important, at the law application stage, when the legislator empowers the public authority to make a decision to resolve the conflict by making a decision in the case. This mechanism of weighing up values are adequately contained in the provisions of the Constitution. First one is Article 31, subsection 3 of the Fundamental Law. According to it, any limitation upon the exercise of constitutional freedoms and rights may be imposed only by statute and only when necessary in the democratic state for the protection of its security or public order, or to protect the environment, health or public morals, or the freedoms and rights of other persons. Such limitations shall not violate the essence of freedoms and rights. On this background, we can say that this regulation is conventionally indicated as a proportionality principle. It covers the formal, it is statute, and material condition of lawful limiting realization of a given value for the sake of implementing another value listed in this provision. Example, state security, public morals, and so on and so on. Of course, this provision also covers the requirements, suitability, necessity, and proportionality in the strict sense of the term. I won't describe it because of lack of time. Against this background, three additional remarks should be made. First, the jurisprudence of the CC, in this jurisprudence, the above mentioned rules are also followed, mutatis mutandis, in the sphere of applying the law. So, not only lawmaking process, they are binding for these authorities. Second, according to the notion protect the environment, as a premise for the limitation of values, we can ask whether the value underlying this protection should be reduced exclusively to the healthy and ecologically safe environment, understood through the prism, only through the prism those mentioned above Articles 68 and 74, or should it be understood more broadly, environment optimal from the point of view of various environmental measures. Example, biodiversity, valuable habitat, and so on and so on. I think that there is much to be said in favor of this broader approach. And third, this article of the Constitution refers only to the restriction of values regarding the protection of human and citizens' rights and freedoms. So, in particular, it concerns the broad access to environmental information, but that does not refer, example, for the ecological security, because we don't have subjective right in this arena. Referring to the last item above, the jurisprudence of the CC derives an analogous mechanism of weighing up values with a different objective scope from Article 2 of the Constitution. The Republic of Poland shall be a democratic state ruled by law and implementing the principle of social justice. And this provision is a source of the also proportionality principle and the test of suitability, necessity and proportionality sensu stricto, but concerning here, according to the CC view, the limitation to realization of values underpinning the constitutional rights of public entities. For example, local self-government entity or higher education institutions. So that's I think that this is a specific situation. In the context of our issues, I mean the Article 2nd of the Constitution may be relevant example in the case of collision of the values, the independence of local self-government, especially in a financial dimension, versus the optimal condition of the environment. And I believe that there is one further constitutional provision referring to the mechanism of axiological calculus. The mechanism is in particular directly concerns the limitation of the value called the optimal quality of the environment. Specifically, it results from Article 5 of the Fundamental Law, but the jurisprudence of the CC and the systemic interpretation of the Fundamental Law play a crucial role in extending this concept and this mechanism. Article 5 you have on the slide. The Republic of Poland shall safeguard the independence and integrity of its territory and ensure the freedoms and rights of persons and citizens, the security of the citizens, safeguard the national heritage, and shall ensure the protection of the environment pursuant to the principle of sustainable development. We don't have, of course, a constitutional definition of the term sustainable development, but we have once more the judgment of the CCKP 209, in which the Constitutional Court suggests defining this notion through the prism of the statutory provision. I mean the Article 4.50 of the Environmental Protection Law. And sustainable development means such social and economic development which extends to the process of integrating political, economic and social actions with maintaining the environmental balance and stability of basic natural processes with a view to guaranteeing the capability of satisfying the basic needs of particular communities or citizens of both the present and future generation. For the CC, this concept, I mean the principle of sustainable development, also requires that the interference with the environment should cause the least possible harm and the social benefits should be proportionate and socially acceptable relative to the damage caused. It is also KP 209. Furthermore, the CC, in several decisions, has expressed its view on the issue that causes probably the greatest argument. It as the scope of the principle of sustainable development. In this context, the CC indicates that the idea of sustainable development includes the need to take into account different constitutional values and balance them appropriately. Moreover, the CC has referred to the principle of sustainable development several times also in cases related to financing of local self-government units. On this ground, it stated inter alia that the above-mentioned principle is one of the bases for introducing the mechanism ensuring protection for financially weaker communities. These decisions did not address the environmental issues at all. In the light of the above, the CC, for me, unequivocally declared the necessity of applying the sustainable development principle in a broader scope than just environmental protection, even arguing for the independent character of this principle, including precisely the mechanism of weighing up values. Unfortunately, this proposal of the CC was neither broadly motivated nor a part of a broader concept. It makes the application of the value weighing mechanism problematical. Nevertheless, starting from the assumption of independent, autonomous character of the sustainable development, we should assume as follows. There are two groups of conflicted values encoded in this principle. It is development in social or economic dimension and values relating to the adequate quality of the environment, or other conflicted with the pro-development value. Example, cultural goods, appropriate condition of public finances, property of state treasury, and so on and so on. And it should be stressed that it is not necessary to interfere in the condition of the environment to apply this principle. Furthermore, the principle of sustainable development provides guidelines for weighing up these values. It is integrating them, guaranteeing the possibility of satisfying the needs of present and future generations, limiting them according to the directives of suitability, necessity, and proportionality sensu stricto. And conclusions. The Constitution quite clearly indicates the basic catalogue of values directly related to environmental protection. It is not very extensive, 3 values. It is rather difficult to determine the content of the value underpinning the constitutional obligation to protect the environment. The Constitution is ambiguous as to whether it refers only to a healthy and ecologically safe environment, or more broadly, to its optimum condition in various environmental aspects. The above mentioned environmental values variously interact with each other and with other constitutional values, including in particular, of course, the relation of conflict. The resolution of this conflict requires application of the mechanism of weighing up values, which rests on the principles of proportionality and sustainable development. Thank you very much for your